what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the articles of impeachment had been constituted, the court was specifically asked, told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of its agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin to? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap? At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco, case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. 200 milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation na dapat sole jurisdiction din ng Kamara? Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagrereklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga mahistradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber, and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at the time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law because under our Constitution, decisions of the Supreme Court form part of the law of the land. I made these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience have been aided and abetted by so-called legal luminaries and experts who fancy their wisdom and knowledge of the Constitution as better, higher, more supreme than that of the Supreme Court. Miyembro po ba sila ng Supremist Court? Miyembro po ba sila ng Super Supreme Court? Sa pagkakaalam ko po, iisa lamang ang Korte Suprema. At ayon sa ating konstitusyon, Korte Suprema ang bukod tanging pwedeng makapagsabi kung ano ang kahulugan ng ating saligang batas. Walang iba. Allow me to demonstrate, for example, Mr. President, the legal gymnastics these people have been undertaking. In the past, and I have borne the brunt of this, sabi nila, forthwith ang sinabi sa Senado, ibig sabihin yan agad-agad. Despite the rulings of the Supreme Court that say it is within a reasonable time. Pero doon na tayo sa agad-agad. Sabi ng rules ng House, dapat i-refer ng SecGen immediately sa Speaker. 2 buwan bago niya ginawa yun. Oh, okay lang sa kanila. Hindi naman sila nagreklamo. Immediately po ang gamit, ha? Hindi forthwith. Sabi naman ngayon ng Korte Suprema, immediately executory. Ay, teka lang. Hintayin muna natin. Hindi pa final. Kapag ka convenienteng gamitin yung mga salita pabor sa posisyon nila, edi okay lang. Kapag ka hindi naman, ay hindi rin. Hindi po ganun dapat yon. Hinihiling nila ngayon sa Senado na ipagpaliban muna ang anumang aksyon para intayin ang anumang desisyon ito kaugnay sa motion for reconsideration na inihain ng Kamara sa Korte Suprema. Subalit tulad ng naipaliwanag na kanina kaugnay ng motion na pinagbobotohan natin ngayon, kung magbago man ang Korte Suprema sa kanilang desisyon na unanimous noong July 25, 2025, meron pong paraan at proseso pa ang Senado para sundin ang bagong desisyon yan ng Korte Suprema kung sakasakaling mangyayari po yan. In the past, it was also said, nauna nagsalita si Senator Bato, bawal daw at walang karapatan mag-motion ang sino mang Senator Judge. Dahil trabaho daw ng depensa yon.